Hello, the person whose screen is denominated RAK, would you identify yourself for the court, please?
Court observer?
Right. The reason that I'm checking in with you, certainly you have a right to observe the proceeding, is that I noticed in one of the court's prior hearings, you were popping in and out of the Zoom, and we're trying to get a record. And so the popping in and out, wasn't quite sure what the problem was, but it was a little bit disruptive. So I just wanted to check in on whether or not you have a good Zoom feed, or if that was something, a technical issue happening on our end where you were getting kicked out. I just wanted to see if I could check in with you about that before we get started, with the hope that we could reduce that kind of traffic from happening.
I apologize. I think that I was in the wrong Zoom meeting earlier. And when it became evident to me that I wasn't in the right one, I wanted to get out because I didn't want to be.
Okay. All right. Well, very well. Again, you're welcome. Of course, the public is always welcome to observe the court's proceedings. I just wanted to try to deal with that technology issue because, as you can see, we got a lot of people on this one. And so adding any kind of technology issue to what we already have our hands around just makes things more complicated. So thank you very much for responding to the court's question. No problem.
Thank you so much.
Thank you.
And there's one more person in the waiting room, Rosemary.
Anyone know who would be appearing with the name Rosemary? I don't know who that is, but we'll find out.
Your volume cut out, Judge.
Is that better? Are you able to?
Oh,
are you able to hear me now?
Yes.
I don't know what we're going to do with Dallas County Zoom license, but it clearly is not working the way it's supposed to. So we'll take those issues up with IT when this day has concluded. But in the meantime, we will just do the best that we can, as we have become accustomed to doing for the last 13, 14 months. So what I was asking Ms. Williams is if you still have the list from this morning, such that we don't need to do the roll call before we go on the record, or would you like to do that again?
I just needed Mr. Alexander. Are you taking the place of Mr. Finley?
No. I'm actually co-counsel with Mr. Ligon for defendants City of Dallas, Teller, and Darnell, and I'm just observing.
And then Mr. Scarlatos.
Yes, Matthew Scarlatos, I'm a court watcher.
Okay, and then Jeffrey Morgan.
I'll ask Mr. Morgan to unmute himself. Not having any success with my request to Mr. Morgan to unmute himself. So I will ask the other counsel on the Zoom and Mr. Miller, if you recognize the name Jeffrey Morgan, and is that someone that you recognize as an attorney affiliated with the matter?
I do know Jeff Morgan, but he's not an attorney.
Okay. Is your suspicion then, Mr. Miller, that he's just observing the proceeding but won't be otherwise participating?
I believe that's likely, Your Honor.
Okay. All right. Thank you then. Is that also true, Mr. Miller, of the person whose screen is denominated as Rosemary? Does that ring a bell to you at all?
I don't know any Rosemaries. I don't know who that is.
All right. I'll ask Rosemary, and I apologize for using first name, but that's all I have. Miss Rosemary, to unmute yourself.
Yes, I'm here as a court watcher.
Okay, thank you very much, ma'am. I appreciate that.
Thank you.
And are we waiting on Mr. Finley, or he's not gonna appear on this?
The proceeding certainly has been noticed to everyone. Let me just double check. It's not, Mr. Finley is not representing the move-in, so he may have elected not to participate.
Then I'm ready.
Okay. All right, if you will initiate the live stream. We are on the record in cause number 2015614. This is the case styled Bradley Miller versus Virginia Tally Dunn et al. Counsel, I will give you the opportunity to introduce yourselves, of course, in the order in which your client is listed in the pleadings. We'll start, of course, with the plaintiff, Mr. Bradley Miller. If you would just state your full name for the benefit of the record.
Yes, Your Honor. Bradley Miller, pro se plaintiff.
All right, thank you. And do we have anyone appearing on the Zoom on behalf of Ms. Dunn, Defendant Dunn? Defendant Plumley?
Yes, Your Honor. Scott Graydon here on behalf of Judge Plumley.
I hear you, Mr. Grayton, but I don't see you.
I'm over here.
Oh, there you are. Okay. All right. Thank you. Okay. And then next, Defendant Diaz.
This is Earl Nesbitt on behalf of Defendant Judge Danielle Diaz. I also represent Defendant Dallas County.
Thank you. Patricia Rochelle.
Judge, your volume went out. Judge, your volume.
I was, before Zoom decided to do its own thing, I was calling for an appearance on behalf of Defendant Patricia Rochelle. Okay, I was just noting that we didn't have anyone appear in the morning proceeding on behalf of Defendant Rochelle, and so that does not surprise me. The next listed defendant is Defendant Finley, and no one appeared for Defendant Dunn a few minutes ago, so I assume.
I'm on, Judge.
Oh, you are? Okay, there you are.
Yeah, Mr. Nesbitt let me know that there was a hearing this afternoon, so it wasn't on my calendar. I apologize to the court.
Thank you. Mr. Finley, safe to say that you are appearing on behalf of yourself and Defendant Dunn?
Correct, Your Honor.
All right, thank you. Next, Defendant Marianne, the estate of Marianne Michalopoulos.
Elena Eric, representing the estate of Marianne Michalopoulos, aka
Well,
Marianne Brousseau. That's the Americanized way.
I've spent some time in Greece. I should know better.
The Greek way is Michalopoulos, but
yes. But we somehow have turned the H into a K, and we just do the best we can. All right. Well, thank you, counsel. And next is the Hockaday School.
Jennifer Littman on behalf of the Hockaday School, Your Honor.
Thank you. Defendant Lyon Decker. Well, Decker and Defendant Taylor are both out, so we are next to Defendant Shigrew.
Laura Sherry on behalf of Defendant John Shigrew.
And finally, Defendant Michael Charles Keller and the City of Dallas, and Defendant Darnell.
Again, for the defendants, Your Honor.
Counsel, I think you broke up just a little bit, so the court reporter may not have gotten your announcement. If you just restate that.
Chevis Ligon for the City of Dallas, Darnell and Keller.
All right, thank you. Okay, so we are here. Well, first of all, did I miss anybody? I think we got everyone. Okay, great. We are here for a 91A motion to dismiss filed by the defendants, City of Dallas, on officers Darnell and Keller. Court has had the opportunity to review the motion and the response. And so counsel, you may proceed with your response to Mr. Miller immediately. Well, you may proceed with your motion and then Mr. Miller will respond. I'm sorry, go ahead.
Thank you, Judge Parker. As Your Honor is aware, this is a very sad case involving a family dispute that roped in public officials, judges, and in my case, the City of Dallas and 2 police officers. The salient facts related to our motion based on the plaintiff's complaint and petition is there was an encounter in the important date of April 11th, 2015. On that day, Mr. Miller alleges that 2 officers, Officer Darnell and Officer Keller, violated Mr. Miller's rights, committed several torts and acts of fraud related to removing him from a public venue, the facts of which are immaterial, but the disputed issues relate to whether or not it was right for my clients, the officers, to remove Mr. Miller. The encounter, again, was April the 11th, 2015. Our 91A centers on the statute of limitations issue here. The first complaint that related to Mr. Miller's alleged denial of rights and injuries from that April 11, 2015 event was filed in federal court on March the 31st, 2020. As Your Honor is aware, the sister state court filing was filed on October the 15th of 2020. So in the federal court, it's nearly 5 years after the event that our clients were involved in. And in the state suit, it was well in excess of 5 years. To break down what Mr. Miller has alleged as far as causes of action related to the April 11, 2015 event, we can put them in 3 different buckets. The first are essentially personal injury claims related to intentional infliction of emotional distress, things that sound in tort related to assault or deprivation of rights, conspiracy, that sort of thing. Those personal injury claims, state court claims, are subject to a 2-year statute of limitations. The second bucket of claims involves deprival of Mr. Miller's constitutional rights. Those would sound only in a 1983 claim. There is no Texas statute for 1983. There is no other mechanism to file suit against a municipal official like Officer Darnell, Officer Keller, or the City of Dallas. The 1983 claims, as we detail out in our brief, are subject as well to a 2-year statute. And the third bucket and last involve claims of fraud. These claims are subject to, of course, the 4-year statute. And so going back quickly through them, the personal injury claims and the 1983 claims are obviously well in excess of having blown the statute of limitations. The fraud claims should have been filed, even assuming that they are viable. The fraud claims should have been filed by at least, or the latest, April the 12th of 2019. That's almost a year before Mr. Miller filed his federal court case. In our, or in Mr. Miller's response, if you go through it in the introduction and all throughout, the gravamen of Mr. Miller's complaint involves the April 11th, 2015 event. The alleged injuries and damages, rather, that are continuing is of no moment. The instance that matters is the April 11th event, and that is shown throughout his brief. Nothing in his brief or in his response to our motion explains why these statutes should not be applied. For example, in the fraud issue, there are no pled facts in his complaint, nor mentioned in his response that my clients, by and through their officers Darnell and Keller, committed acts subsequent to this. Whether the damages that officers Darnell and Keller inflicted upon him continued is of no moment. Secondly, there's no issue about whether this was not a discoverable offense. He was there, he knew about it. And so there's no tolling of the statute based on something that we hid or that wasn't knowable at the time. The claims against the city of Dallas are essentially Monell claims. Those are
I'm sorry, they're essentially what type of claims?
Monell, M-O-N-E-L-L. I'm sorry. And the Monell claims sound in 1983, in a 1983 suit. As we noted before, 1983 claims have a 2-year statute of limitations. Mr. Miller's response and all the case law either does not contradict that. So we've got that which is insurmountable. Mr. Miller, who the city will and officers Darnell and Keller will stress, empathize with this very difficult situation and cast no aspersions on him or doubt the suffering that apparently has gone on in these many years since the family dissolution. But this court's focus has to be on April the 11th, 2015. Now, secondly, Mr. Miller claims that part of what occurred on April the 11th, 2015 was part of a conspiracy and taken from his 130 plus page complaint and also his response. It seems what he's alleging is that April 11th event, my clients were taking part in a grand conspiracy to deprive him of his rights. Just as in a 12v6 in federal court, we have to assume that's true. And it doesn't matter whether he's suing, especially if he's trying to attach liability on the city. Again, through 1983, that's a 2-year statute. Mr. Miller also, to go back to the conspiracy issue, as we highlighted in our brief, even if the conspiracy was ongoing, which he does not plead, there are no facts in his brief or complaint that would allege this. At no point are my clients mentioned to have done extra things. 3 years later, did it again, or 3 years later had anything to do with it. So it all comes back to the 2-year and 4-year statute. As a tertiary matter, but nonetheless illustrative, as we highlight in our brief, the Texas Tort Claims Act does not allow individuals to be sued for intentional torts. So we think the fraud claim falls, and all of the intentional tort claims, of which there are many, fall for that reason alone. Secondly, even if those claims are viable, they do not attach to the city for the same reason of the 2-year statute. Lastly, Mr. Miller, who gamely makes a valiant effort to try to save his claim, at the last part of his brief challenges the constitutionality of the statute of limitations. He does not cite any case law or any emerging trends in state or federal court to say that the due process clause has anything to do or is amenable to tolling a statute based on the reasons that he cited, all of which are frankly personal. He states that he's been in dire straits due to the litigation load and the difficulty in filing these claims on his own. On that note, Your Honor, I would note that these claims were known to him in 2015. He has proven himself to be a very capable filer of petitions, complaints, motions, emergency motions, appeals, and so while the statute has not run, he has frankly nothing to complain about with the difficulty, albeit real, of a pro se individual having to file claims. Lastly, Your Honor, as we mentioned this morning, pro se individuals, while courts are known to give latitude both in state and federal court on technical matters, the statute of limitations is the statute of limitations. That is something that is available to all. That's not a hyper-technical rule of civil procedure. It is not a concept that particularly someone with the intelligence of Mr. Miller can't understand. And so at this stage, there's really no justification for this case to go on. Under law and fact, none of the alleged deprivations of rights occurred based on his pleadings and based on his responses within the applicable statute of limitations. And so for that matter, for that reason, they should be dismissed. Thank you, Judge.
Thank you. Mr. Miller?
Yes, Your Honor. First, I'd like to say I appreciate Mr. Ligon's professionality. Professional.
Mr. Miller, you muted yourself.
It muted itself.
There we go.
Yes, I have Judge Parker's computer problems going on here. Anyway, I was saying that I appreciate Mr. Ligon's professionalism throughout this so far, and he's been an exception in that regard. I want to address one thing right off the bat before I start to say what I was, and that was what Mr. Ligon said about my being a very capable filer. I certainly didn't start out that way. I knew nothing about the law prior to my divorce case starting in 2013, and it took me a solid year to learn enough to file my first mandamus in the Texas Supreme Court. So that's some indication of why I haven't filed this suit before now, because number one, I didn't know how to do it. And number two, I was so busy trying to get my rights back to free speech and the right to parent in the appellate courts with regard to orders that Judge Plumlee and Defendant Diaz also had issued without jurisdiction, that it took all my time, and it was just not possible. There's only so much that one person can do. But that's a due process issue that I'll get to. Just to say what I was going to start out with, as Mr. Ligon indicated, the suit against the City of Dallas and DPD officers Darnell and Keller stems from an Dallas Art Fair incident on April 11th, 2015. That's correct. And that was part of a campaign of harassment that's been orchestrated by Defendant Dunn that has been ongoing since 2013. At the art fair, Defendant Dunn made a false report to police officers Darnell and Keller that she had a restraining order against me. Officer Keller then accosted me when I was outside of a booth in a different part of the art fair after having talked to someone I knew there, and asked my name and escorted me to a foyer where Defendant Darnell was waiting. The two of them asked me if I had a restraining order, and I said no. They then called dispatch and verified that I did not have a restraining order, but they told me that I would have to leave or they would charge me with criminal trespass. This is based on a false report to a police officer, which is a crime under TPC section 3708. They evicted me on Defendant Dunn's false report and on their own initiative. No one else requested that they do it. In fact, we spoke with an art fair representative named Tracy Moberly, who had no idea what was going on, and she said she just had to do what the police officers told her to do, and that's what they did. They evicted me without cause. Their actions violated my First Amendment right to freedom of assembly and my Fourth Amendment right to unreasonable searches and seizures.
I'm sorry, Mr. Miller, can you slow down?
Sure, sorry. My Fourth Amendment right to freedom from unreasonable searches and seizures. I am indeed also alleging conspiracy, which has been thoroughly pleaded in the plaintiff's original petition at pages 35, 87, 90, 108 through 109, 123 through 124, and 136. I am alleging that defendants Darnell and Keller worked in conjunction and collusion with defendant Dunn to commit fraud and rights violations. The acts of these defendants meet the elements of fraud. Dunn made a false representation that I had a restraining order. At least Dunn knew that this reputation was false, and potentially her employees. Dunn induced others to act upon this false representation. Darnell and Keller even determined that the report was false and acted upon it anyway, with a complete disregard for their duty to the law. Defendants Darnell and Keller relied on the false representation, which then injured my rights, resulting in damages. The acts also meet civil conspiracy standards. Two or more people, the object of rights deprivation, and a demonstrated meeting of minds, unlawful constitutional violations, and damages caused. Those standards are set forth in Massey v. Armco Steel, 652 Southwest 2nd, 932. That's Texas 1983. The damages also, as Mr. Ligon indicated, include emotional distress, which has been extreme and ongoing for years, and that one event was stressful enough, and financial harm to me. The fraud was—
Mr. Miller, pardon the court's interruption, but I just want to confirm that the one event that you're talking about is the event that happened at the art fair.
Yes.
On April 15th, or
Yes,
excuse me, on April 11th, April 12th.
April 11th, 2015, yes.
Yes, okay, thank you.
Yes. That was the one incident in which defendants Darnell and Keller were involved. Defendant Dunn has been involved in more than that. The fraud was the amount of my being deprived of the value of my art fair admission, which was small, but still a deprivation, and the time it took to file complaints after that, which deprived me of income. Thus, fraud and conspiracy to commit fraud are applicable claims, as are civil rights violations and conspiracy to interfere with civil rights, which are answerable under 42 U.S. Code sections 1983 and 1985. And I will eventually amend my suit to include claims under 1985 as well. As far as sovereign immunity, defendants Darnell and Keller have no sovereign immunity for illegal acts. They evicted me from a public place without cause and committed this act in a conspiracy with defendant Dunn and perhaps others. Thus, they at least violated 18 U.S. Code section 241, conspiracy against rights. And because they did so while wearing a police uniform and serving as officers, they also violated 18 U.S. Code section 242, deprivation of rights under color of law. The Texas Supreme Court has ruled that, quote, suits to require state officials to comply with statutory or constitutional provisions are not prohibited by sovereign immunity, even if a declaration to that effect compels the payment of money. In that case is City of El Paso versus Heinrich, 284 Southwest 3rd, 366 at 372. That's Texas, 2009. This suit is brought against Keller, Darnell, and Dallas to force compliance with the First and 14th Amendments. So the City of El Paso ruling applies. Also, as that ruling continues, quote, a state's official illegal or unauthorized actions are not acts of the state. Accordingly, an action to determine or protect a private party's rights against a state official who has acted without legal or statutory authority is not a suit against the state that sovereign immunity bars. And that's the same ruling, quoting Federal Sign versus Texas Southern University, 951 Southwest 2nd, 401 at 404. That's Texas, 1997. Defendants Darnell and Keller are not the state. They violated the law, thus they are deprived of sovereign immunity from those acts. Further, Mr. Ligon mentioned the Texas Tort Claims Act, which does not apply in this case for this reason. Texas Civil Practices and Remedies Code, section 101.106F, specifically states, quote, this chapter does not apply to the wrongful act or omission or the negligence of an officer commissioned by the Department of Public Safety if the officer was not on active duty at the time of the act, unquote. And that's in uniform or not. Officers Darnell and Keller were not on active duty that day. They were, they stated to me, in fact, and which this is in an affidavit attached to my petition at Exhibit C on page 3. They stated to me that they were employed by Ray Hunt, who was the business owner or the building owner at the art fair location at the time. Thus, the election of remedies under Texas Tort Claims Act, Section 106.002 does not apply, nor does the entire chapter. But thus, both the city and the officers can be sued. Further, the city of Dallas is also deprived of sovereign immunity for failing to discipline officers Darnell and Keller for these acts. I filed a Dallas Police Department complaint against these two officers on June 10th, 2015. That was Dallas Police Internal Affairs Control Number CN 2016-161. I also testified about this incident before the Dallas Citizens Police Review Board on April 11th, 2017. The DPD found no wrongdoing and did not discipline either officer for the actions they undertook at the art fair. It's true that citizens are not normally subject to suit for their employees' conduct. I'm sorry, cities are not normally subject to suit for employees' conduct unless those employees act pursuant to official policy. And Mr. Ligon cited Monell versus Department of Social Services, and that citation is 436 at 663 note 7. In that case, his citation is US 658. I'm sorry, US 658, 1978. The plaintiff must allege facts sufficient to show that a city or municipality, through its policymakers, formulated or had constructive knowledge of an official policy that sanctioned or encouraged a deprivation of rights protected by the Constitution. And that's from Webster v. City of Houston, 735 Federal 2nd, 838 at 841, 5th Circuit, 1984. In this case, I brought a complaint of clear constitutional violations to the Dallas Police Department, subjecting the incident to official review, and my complaints were dismissed without further action. In St. Louis v. Paprotnik, that's P-R-A-P-R-O-T-N-I-K, the United States Supreme Court held, quote, when a subordinate's decision is subject to review by the municipality's authorized policymakers, they have retained the authority to measure the official's conduct for conformance with their policies. If the authorized policymakers approve a subordinate's decision, the basis for it, their ratification would be chargeable to the municipality because their decision is final. And that's City of St. Louis versus Paprotnik, 485 US 112, that's 1988. By reviewing the actions of officers Darnell and Keller and approving them, the City of Dallas ratified the conduct of these defendants, their police officers, and established that this conduct was in keeping with the policies and standards of the city and its police department. Thus, the dismissal of my police complaint is a ratification that is chargeable to the City of Dallas. Further, the recent history of the Dallas Police Department, even in the interim since this incident, has clearly demonstrated that police misconduct has become so common as to represent a municipal policy. Just to give 3 examples, there was the death of Tony Timpa at the hands of Dallas police officers back on August 10th, 2016. In an incident that was very similar to the one in which George Floyd died. Then there was the shooting of Botham Jean by Officer Amber Geiger, September 6, 2018. And the recent case of Officer Brian Reiser, who was in the news recently because he was implicated in a 2017 murder for hire plot, but was allowed to stay on the police force on patrol while under investigation. Obviously, my case is mild in comparison to those, but it shows that Dallas police officers too often have no respect for even the most fundamental law, our Constitution. Do officers Darnell and Keller know the First Amendment? And if not, why not? Why are they not being trained in the rudiments of the law? They are law officers of the law, and they need to know the basics at least. This is not tax code. It's basic law. In 2001, the United States District Court for the Southern District of Texas ruled, quote, to demonstrate governmental policy or custom under Section 1983, a plaintiff must at least show a pattern of similar incidents in which citizens were injured and or endangered by intentional or negligent police misconduct and or that serious incompetence or misbehavior was general or widespread throughout the police force. And that case is Paz v. Weir, 137 Federal Supplemental Seconds, 782 at 799, Southern District of Texas, 2001. It is clear from these incidents that the City of Dallas has knowingly condoned and supported intentional and or negligent police misconduct that has repeatedly injured citizens, and that the consistent support of and failure to discipline this misconduct rises to the level of city policy. The City of Dallas itself is thus deprived of sovereign immunity from suit. With regard to the statute
Mr.
of
Miller,
limitations,
excuse my interruption. I know you're about to turn to the last issue of the statute of limitations. Similar to this morning, I do have another proceeding behind yours that was to start at 2. If you'll give me just one moment to check in with them, to let them know I haven't forgotten about them and that I'll be on the line with them, we'll wrap this proceeding up. Just give me one moment,
thank
please.
you, no problem.
Thank you. Mr. Miller, you may proceed.
Thank you, Your Honor. Yes, with regard to the statute of limitations, the defendants in this case, and obviously the city of Dallas and Darnell and Keller have had a relatively minor role in it, but there's been a conspiracy against my rights and conspiracy of harassment that's kept me tied up in litigation, as I said, for more than 6 years and really 8 years, back to 2013. But since 2015, I've been representing myself pro se, filing multiple appeals to regain my right to free speech and the right to parent. And as I said, I've had to teach myself how to do this, and it's not easy. I don't have a law degree. I have to pay child support every month, and I have to be able to support myself somehow, which I can barely do and really can't with all the legal work that this takes. As I said, I lack the money and time and knowledge to file suit until I did in federal court on March 31st of 2020 when I filed a civil suit. The bottom line is that any reasonable application of due process under the 14th Amendment would preclude allowing the statute of limitations for these tortious acts, including personal injury and conspiracy, to run while one or more conspirators keeps an indigent party involved in litigation resulting from their abusive conduct, thus allowing the other conspirators to escape liability for their tortious acts. And that's exactly what happened in this case. Due to this conspiracy against my rights, especially on the part of defendants Dunn, Plumlee, Diaz, and the Hockaday School, and Miriam Malopoulos, who's since passed away, I have not seen my daughter for 3 years. It's incredible that this happens in this country, in this day and age, that court corruption and official corruption even can be orchestrated somehow by private parties against another individual, causing deprivation of rights. Basically, my daughter has been used as a human shield to protect these defendants from accountability. This is an egregious violation of the 14th Amendment right to parent. And it's been conducted by at least 4 state officials, as I said, defendants Plumlee, Diaz, Darnell, and Keller, all of whom took an oath to uphold the laws and Constitution of the United States, and yet somehow are failing regularly to do so. That's, as Mr. Ligon said, I'm challenging as unconstitutional the Texas statute, 2-year statute of limitations for personal injury and conspiracy, and the 4-year statute of limitations for fraud in these circumstances. The Supremacy Clause of the United States Constitution dictates that state laws cannot contravene the Constitution, including the 14th Amendment right to due process. I would therefore object to dismissal under any statute of limitations for any of the torts alleged herein. And the defendants Dallas, Darnell, and Keller should be held liable to suit for personal injury and conspiracy as well as fraud, and the suit against them should proceed. Thank you, Your Honor.
Thank you. Counsel, I will give you the final minute. I've got just about a minute remaining to wrap you all up, and I'll give that to you as the moment.
Thank you, Judge Parker. The previous illustrates the problem we've been dealing with. Mr. Miller takes a lot of different legal ideas and pushes them together to try to see which one sticks. For example, he's saying that the officers were not acting under color of law. Well, if they're not acting under color of law, then there is no Monell plan. He tries to allege a Monel pattern. My office deals with Monel suits all the time in federal court. A Monel pattern requires a lot more than a couple incidents. The due process here and the statute of this over there, all the court needs to focus on is the fact that he has admitted that all of his allegations stem from the April of 2015 interaction with my clients and Mr. Miller. That is the one instance, is what he admitted, that they were involved. We're not alleging sovereign immunity. At this stage, the best way for us, we're not alleging a lot of things that we could. We're focusing the court's attention on what Mr. Miller has admitted to, which is he has a statute of limitations problem. That's the cleanest way for us to get this out of your Honor's court. I'm sure Mr. Miller will potentially have cases against other people at other times, but nothing in his brief or his oral argument or his pleadings indicates that there was any injury or any deprivation of rights after April of 2015. Thank you, Your Honor.
Thank you. Thank you both for your arguments. In the brief that was filed, the motion to dismiss, Mr. Ligon, you focused the court on certain pages of the pleading. And as we all know, the pleading is quite lengthy, being the petition being in excess of 125 pages. And you'd focus the court on some specific pages and paragraphs, notably pages 35 and 90 and paragraphs 87 and 222. As the place where the court might find the most dense factual allegations against the moving defendants. In oral argument here, Mr. Miller called out several other pages and an exhibit that he asked the court to focus some attention on. So I will get an order out on this today, but I would like to take a look at those other pages to discern whether they relate to something other than this April 2015 incident. I just want to double check it just because Mr. Miller did identify quite a number of other pages and the pleading is so lengthy. I want to make sure that the court doesn't miss anything. So I'll take a look at that before I rule, Mr. Miller, and then I will get an order out related to the motion today. Thank you all very much.
Thank you.
Thank you, Judge.
Thank you. Bye-bye.